right, welcome back to another episode of Modern Cyber. We've got something a little bit different today that I think we're all really going to enjoy. Why? Because we're all individuals and we are all subject to the laws of the nation, states, municipalities, localities, whatever it is, wherever you live in the world. And so we've brought on somebody today to talk about the intersection of law and cybersecurity. It comes up a lot, and I think we're going to get a lot out of today's conversation. So with that, I'd really like to take the opportunity to welcome Jonathan Steele to Modern Cyber. Jonathan is a distinguished family law attorney and the founder of Steele Fortress, a leading privacy and cybersecurity consulting firm. As a partner at Beermann LLP in Chicago, Jonathan has a reputation for handling complex family law cases with innovative legal strategies. His dual expertise in law and cybersecurity uniquely positions him to provide invaluable insights into the intersection of these fields. And in addition to everything that I just said, Jonathan has a ton of accomplishments and achievements both academically and in the community. For instance, just picking a few of them, Jonathan was previously recognized as a rising star by Illinois Super Lawyers magazine, an emerging lawyer by Leading Lawyers magazine. He's been consistently acknowledged for his outstanding legal acumen. He's proficient in the Illinois Supreme Court rules. There's just, the list goes on. And in addition to all of that, he's got a CompTIA Security Plus certification. How many lawyers do you know that can say things like that? Jonathan, I don't know where you find the time to fit it all in, but thank you so much for making the time to join us on Modern Cyber today.
It's a pleasure, Jeremy. Thanks for having me.
Like I said, we don't often get an opportunity to talk to somebody like you with this background. I'm not sure I've ever met somebody with this kind of unique overlap of skills in two areas that are super relevant in the modern digital space, law and cybersecurity. So I'm really curious to kind of hear from your perspective. Let's start by talking about where family law and cybersecurity intersect. How do digital privacy concerns impact legal cases, especially in legal cases around family law?
There's a great deal of intersection. So, at the infancy stage of a divorce case, for instance, a spouse might come in and they're feeling vulnerable. They're pretty sure that their spouse has access to whether it's their devices or their data, or maybe they're sharing an iCloud account, or they're worried that their spouse has access to their location services. It's hard to assuage them of that fear without just being able to walk them through the process, walk them through their settings, and help them navigate and sort of unplug all of the access that they've either intentionally or maybe even inadvertently given to their spouse throughout their relationship.
Wow. I didn't even think about it, but as you were going through that answer, I was like, oh yeah, I share my location with everybody in my family. I share an iCloud account with everybody in my family. I've got a password vault that has other members of my family as kind of backup members. So with that kind of, I don't know what the right word, kill switch maybe is the mechanism, but certainly my spouse could get access to all of my passwords in case of a tragedy or something like that. And so I hear about things like, stalkerware and these kind of tracking apps that are often kind of covertly installed on significant others' devices, or I guess soon to be former significant others' devices. But actually the concern, it sounds like, goes well beyond that, even to just the basics that you might have granted access to other people over the course of a relationship, right?
Yeah, the spyware or the stalkerware, that's a more sophisticated threat. That's going to require someone that has a little bit more technical know-how to set that up. What I see more frequently is just the basics. You shared a photo album with your spouse. You shared your location access and the Find My settings, or you even have your iMessages being replicated to another device in real time that your spouse has access to. And so it's things like that, and it's Apple has done a good job with their feature Safety Check that is designed specifically for like a domestic abuse situation that just walks you through in a real Apple-friendly way of unplugging that access, showing you what sort of permissions you've given and to who, and asking you if you want to keep those permissions existing or to cancel them. And that's a good place to start for a lot of people.
And, to the extent that you can estimate, in what percentage of cases, let's say divorce cases specifically, does this come up? Is it like 100% of cases nowadays? Because that's just how our lives are now?
I wouldn't say it's 100%, but it's pretty common. A common one is email, and email
Yep.
concerns me greatly because that's going to be one of the main ways that my office is going to communicate with clients. And to preserve the attorney-client privilege is something that I'm hyper vigilant about. And so, if I have a fear that the opposing party is reading emails between me and my client, I need to fix that as a high priority. And so, it involves, changing passwords, buttoning up two-factor authentication.
Right.
If in your case, removing access to the password vault.
Yep.
If you change the password, but the other person still has access to the vault, you haven't really solved the problem. So, email is going to be crucial. Text message, iMessage, Signal message, however you're communicating with your lawyer, those are sort of top priority tasks. But then just email is a treasure trove of information for someone that is trying to build a case against you. So cleaning that up is very high priority.
It's funny. I mean, just kind of going back to what I said earlier, my mind immediately went to the case of kind of like, infidelity or suspected infidelity. And I think about, oh, well, yeah, I don't want this person to have access to my email because they might find out the bad things that I've been up to. But it's actually far more than that. It's even just, maintaining private personal communications with somebody like a lawyer, a banker, an accountant, as you might be kind of disentangling two lives or something like that. I wonder, could you give us any examples? I obviously there's confidentiality and privilege and things like that, but maybe there's some public examples that you could share with us to try to make it a little bit more concrete about how this plays out and how information found through these digital means has really impacted a case.
At least where I practice in Illinois, if you've gathered evidence in a way that you shouldn't have, if your spouse did get access to your email and they found something damaging and they want to use that in their case, it's most likely going to be barred from an evidence perspective. It's fruit of the poisonous tree. But even if you can't directly use the evidence, you're learning information about the person that you can use against them, whether you can use the evidence or not. And so, an example might be in Illinois, if you are a maintenance or what's formerly known as alimony candidate, and you are cohabitating with someone of the opposite sex while you're in the middle of your divorce case, you might lose your right to maintenance. You might lose your right to alimony. And one way of finding out that you're cohabitating could be something like emails. You might have Expedia confirmation where you're traveling with a significant other. Or maybe you forgot to unplug your spouse's access to your Ring cameras or to your Nest cameras, and so they're seeing the person coming or going. Or maybe you were smart enough to put your social media accounts on private, but you pruned a number of either acquaintances that you share with your spouse, and certainly probably removed your spouse as a follower, but maybe you didn't prune all of them. And so maybe you have a mutual friend that's sort of passing along in real time photos that you're uploading to Instagram that show you on vacation. All these little things add up to a big picture, which is you are cohabitating. And so you might lose your right to maintenance. And on a similar vein, in Illinois, if you are wasting money or spending money on something that's unrelated to the marriage, you might owe that back to your spouse. So if you're traveling the world with a significant other and you can tie that up through emails or through iMessages or through photos, you've done yourself a great disservice. And so it's very well advised to clean that up as best you can. You've got a digital footprint out there, and you need to make it as small as possible and as inaccessible as possible.
So just so I'm clear on it, all of the things that you just said would be effectively admissible. So if I've, removed all these people from social media, but I forgot one who then shares a picture of me and a new significant other with my ex, that's admissible because I've posted on social media where that person, didn't do anything nefarious to gain access to that content, to that photo, but then shares it. But if I change my password and use two-factor authentication, but my spouse or my ex still somehow gains access, then they're going out of their way to kind of circumvent the protections that I put on my accounts. Is that a fair summary?
Yeah, in the latter case there, they did something wrong. So that should be inadmissible. But when you're just voluntarily putting your photos out there into the world, you're making a choice. You're doing that voluntarily. No one forced you to do that. Nobody did anything wrong. It's you put it out there in the public, and somebody saw it, and that's your fault. That's going to be admissible, and that's going to end up getting used against you in that scenario.
Yeah, it's crazy. I mean, I'm fortunately I'm not in a position where this is a real situation that I need to consider in my life, but these are things that I never would have thought of, and I imagine those who haven't gone through a separation process probably don't think about this as well. So this is a little bit eye-opening for me. When you talk to people through this, other than, let's say, inadvertently sharing information, what are some of the other common mistakes that you see around digital privacy during these legal disputes? I know you mentioned things like, let's say, forgetting to stop sharing a Ring camera or a Nest camera or maybe photo albums. Do you have like a checklist, or how do you think about that with your clients?
I tried to encourage people to get off of social media, and I realized nowadays that's like asking somebody to give up a limb. And so it's going nowhere. That's a conversation that is tough to have with someone. But getting them to clean up their friends list or their followers list can be an easier sell for people. And so that's a good starting point. And then, I try to encourage people to try to compartmentalize different parts of their life as best as possible, because that's going to help to mitigate damage in the event that your spouse has access to something. And so, if you have, for instance, you're using an email alias service, or you're using something like a MySudo or a Cloaked, those are going to have a number of benefits associated with them, one of which is you're just segregating different parts of your life. And so if you have a pseudonym that's attributable or associated with like your online dating persona, for instance, and your spouse gets access to just your general email box, they might get your Amazon receipts, your DoorDash receipts, but they maybe don't get access to your dating life. And then, that's going to pay dividends in other areas as well. If you end up dating someone that turns into a stalker, it's pretty easy to cut that off because they really only had access to your pseudonym phone number, your pseudonym email address. And it really just does help to mitigate the damage that can come from either whether it's a data breach, a hack, an over-intrusive spouse. So I try to push people towards MySudo. And then I try to encourage people to use, as much as I can, more secure communication methods. So with my clients, I try to move everybody onto Signal because I think it's just a more secure platform. I think iMessage generally does a good job, but Signal does better. And then, if I can get people off of like a Gmail onto something like a Proton Mail or to a Tutanota, that too can be a hard sell. Gmail is just an easy, everybody uses it kind of thing. And, best case scenario, usually I get people to create a second email address and they will communicate with me using their Proton Mail. It's hard to get people to just abandon their Gmail. So, there's a number of different things that I try to triage, whether it's first, if we're going to communicate using our mobile devices, let's get on Signal. If we're going to send each other emails, let's try to use Proton. If we're going to send each other attachments, let's try to use a secure file upload service as opposed to just sending email attachments. Because then if your spouse does get access to your email, what they have is a bunch of expired links as opposed to all the different attachments that we've exchanged during the course of your representation. So Gotcha. I know I gave you a lot there, but that's it's a checklist, I guess, that I do try to run through with clients to sort of keep their exposure limited.
And for anybody who may unfortunately be going through this process right now, you can just kind of click back about 2 minutes and go through that section of the podcast episode again and get that checklist as well. I'm curious, we're mostly talking about an adult to adult here, right? Who, for one reason or another, are deciding to end a relationship. What about the impact on the digital footprint of children?
That's a huge one because, first of all, there's the digital privacy and the security of the kids themselves. You put an iPad in the hand of a 6-year-old and 1 minute they're watching Bluey and you come back an hour later, you took a shower, you worked out, whatever, you come back and they're watching something that's traumatizing. And so, you need to put some belts and suspenders on these devices so that, you're protecting your kids.
Yeah.
That's the primary concern. But there's a secondary concern that I think is pretty often overlooked, which is that, if I'm divorced and I give my child an iPhone, I now have the ability to track that iPhone. And so when my child is with my child's mother, I now probably have the ability to track my child's mother. And so my child is essentially then a tracking
proxy
for my significant other. Or, a lot of people now our parents are AirTagging their kids, and I think that's smart nowadays. But the same thing is applying when the child is with the other parent. And so, it's a responsible thing to do if you are now assuming parenting time to know what devices your kids have, what access is given to the other parent. If you have the ability to turn that off, great. If you have the ability to give your child a different device when they're with you than when they're with the other parent, great. But, there's that dual concern there, one of which is just protecting the kid themselves, and then there's protecting yourself because the child can be, like you said, a proxy for information to you.
Yeah. And does the COPA play into this at all? The Child Online Privacy Protection Act, does that tend to get wrapped up in some of these family law cases?
It's still pretty new, but it does. It affects more of that first concern about how we're protecting the kids themselves. It does give or the ability to have some accountability on, websites that allow children access when they shouldn't be given access. It basically attaches liability on companies so that they do a better job of protecting kids and put some of the onus on them as opposed to putting all of the onus on the parents. But even if we're putting some of the onus on the companies, I don't think parents should take their hands off the wheel. They still have that primary obligation of keeping their kids safe. And so it's important to do network traffic protection, device level protection, and really just keep monitoring to make sure that the kids are safe. There's a line there between privacy and security, and you don't want to overstep. And while you're teaching your child that it's important to respect other people's privacy, if you're invading theirs, they're getting mixed messages from you. But it's important to just be open with the kids and say, I'm giving you an iPhone, but it's my device, and I'm going to take it and look through it when I want to, and just be open with them about the fact that you are going to monitor what they're doing. And it's for their protection, and it's to keep them safe, and that's your job as a parent. So I think it's a good start as far as regulations go, to start putting some parameters around companies and have them accountable. But I think it's got a long way to go.
Gotcha. And do you see disputes over digital assets at this point? I think about things like photo albums, and obviously, everybody can have a copy of a photo file or an image file, things like that. But I could also imagine scenarios where one party or the other doesn't want the other party to get or to be able to keep access to, certain memories or pictures or things like that. Does that become an issue very often?
It does. It takes various forms. When you mention digital assets, my mind goes to cryptocurrency. That's something that's common nowadays. But I've also had fights over iCloud albums, and I want duplicate copies of pictures of the kids, and that's a reasonable request, and it's something that's easy to do nowadays. So that comes up a lot, and then more and more now we're seeing actually fights over a domain name that may have some goodwill associated with it. If a couple was, they had a joint business venture and one of them has possession of the domain name, they may end up fighting over that. And that has a value associated with it. And then sort of related, but a little bit more troubling is not so much a photo, but video. Sometimes there may be video of a pornographic nature that comes out of a marriage, and that becomes a hotly contested. What happens to that video? You don't want your spouse to have that anymore. Some people refer to that as revenge porn, that it ends up being circulated. And you can order that it be deleted, but how do you put teeth to that? How do you really enforce that? How do you make sure
it's super hard to enforce?
So that one comes up pretty often, and that's a hot button one because it's worrisome. So just be mindful of you may be in a good place in your marriage right now, and it may seem like a great idea, but keep some control over where that's being kept and whether it's a good idea to record it in the first place.
Yeah, to some extent, I once heard a piece of advice from somebody years ago, which is that basically, like, if you wouldn't want it on the public internet, don't create it. Just because so many people are bad at personal cybersecurity around things like iCloud passwords, around two-factor authentication, etc. And not that you or I are particularly the target or worth somebody's time to go into, but when we know that people are really bad at reusing passwords, and when there are automation scripts that can go test one password against any number of sites, and there are common techniques like, well, let me just exploit you for, even for, as an individual, if it's for a couple $100 to threaten the release of some iCloud photos or whatnot, that is something that I think is probably pretty sage advice. If you don't think you'd be okay with it being public on the internet, you probably shouldn't take it. And I certainly have followed that in terms of the photos and the videos that I've taken in my own life, but I do recognize that, not everybody has. So I asked earlier about kind of stalkerware, and you said that that's a more advanced kind of scenario. That's not a very typical kind of thing, and you deal with a lot of the basics. I'm curious, what are some of the other emerging threats that you're seeing in this space? Whether it is something like a stalkerware or whether it is other things around, let's say, like the possession of cryptocurrency and people kind of going out of their way to hide assets from a loved one or things like that.
Just because it is more sophisticated doesn't mean that clients don't come in pretty certain that their spouse has spyware on their phone. And so,
okay,
I'll encourage people, and I'll often give people a license to a product like iMazing. I don't know if you're familiar with that software.
I'm not.
It has the ability to scan a mobile device for spyware, and it does a pretty good job of detecting spyware. It can detect something that is a pretty sophisticated version, all the way up to something like a Pegasus. And so that puts some clients' minds at ease, that it scans their phone and it tells them either there's spyware and it cleans it, or it tells you that there is none, and that puts some peace of mind for people. But as far as like a more common or an emerging one, I think is this AirTagging. I'm seeing a lot more of that where, it's like you're dropping an AirTag in the other parent's car at a pickup, or, you're putting it in your kid's backpack and it just falling out in the other parent's home. And so you're using that AirTag to keep tabs on, your spouse or your ex-spouse. And maybe you haven't moved on. Maybe you still want to know what they're doing, whether they've moved on. And so I'm seeing, whether it's an AirTag, whether it's a tile, something like that, those are getting misused a lot. And there's not great law around preventing that. People like Apple, or companies like Apple, are doing a better job with the AirTags. Now if it's not your AirTag and it's with you for an extended period of time, it'll start to beep, or you'll get an alert on your phone saying an AirTag's moving with you.
Yep.
So I think they're doing a better job, and I think Google has something similar.
Yeah.
But that is being pretty commonly misused, and along with what I mentioned earlier about the surveillance cameras, I think both of those are pretty common right now.
And are you finding cases of, let's say, surveillance cameras placed in somebody else's residence or dwelling on a pretty regular basis?
I haven't seen a ton of I didn't install this camera and then I found it kind of scenarios. What I'm seeing more of is just, I was pretty sure that my spouse no longer had access to my Nest account, and it turns out, and they may not tell you right away. They may just be collecting evidence for 2-3 years while the divorce case is pending, and then at the end of your divorce case, when you're exchanging exhibits, here's 100 videos we're intending to use at trial, and then you find out all of a sudden that they had access to your Nest camera this whole time, and they didn't do anything wrong, and so they're not inadmissible because you shared access, you knew that their cameras were there, you knew that they were recording, you knew that they were recording video and audio. So you can't claim like eavesdropping or fruit of the poisonous tree. You're just sort of stuck. So it's important to really make sure that you have cut off access to those cameras, or if you really want full peace of mind, take them down, buy a different brand, put up a different brand. If you went with Nest, then go with Arlo.
Ring, switch or whatever. Ring. Yeah. I want to go back. I just popped in my head that earlier you were talking about kind of, let's say, um, gathering evidence during a divorce proceeding of your ex then cohabitating with somebody, and you mentioned that this is the case when it's someone of the opposite sex. Is it only for cases of someone with the opposite sex, and is this a case where kind of the law hasn't caught up to where society is regarding marriage equality?
Nowadays, it can apply to the same sex, but
Okay.
it is a case of that. Illinois, that's somewhat recent that change went into place, but now it does go both directions.
Okay.
That's just the case law, or the law that interpreted the statutes hasn't caught up to the change in the statute so much. But
Gotcha.
Generally it's just cohabitating with an adult on a conjugal basis, which means you're
Right.
having a sexual relationship. So,
Yeah. And it's quite possibly the case that in other states the law may not have caught up, yeah, okay.
yeah, for sure.
Because that is on a state by state basis, as I understand it, right?
It is. Yeah.
Okay. It's so hard. I think, this is one of the areas where I think cybersecurity and kind of legal frameworks have some parallels, but then some differences. For instance, Europe has GDPR that applies across all of the European Union. And then we have a patchwork of states here that have some standard around. I happen to live in Virginia, and Virginia has a state standard around data privacy, and California does as well. And I think maybe Colorado and Washington State and two or three others. But then there's probably 40 plus states that have nothing at all. And so, on the cybersecurity side, when we look at, let's say, data handling and whatnot, we tend to understand those regulations. But I would have I feel like it would be a nightmare trying to wade into the complexity of, international, federal, state, local laws for many of these things. How do you think about that as a lawyer? You only focus on the jurisdictions that you practice in, or do you kind of try to maintain awareness of where these differences are from a federal to state level?
For the most part, it's going to be state laws that are applying in my cases and the clients that I consult with. If there's a federal law that's going to apply also, and so being knowledgeable about that is important. But as far as like data privacy and cybersecurity, there's not a whole ton of federal legislation on it. There's Illinois law. There's what's called BIPA, the Biometric Information Privacy Act, and that was sort of a trailblazer for our country. That did a good job of not allowing companies to collect biometric data without like full disclosure.
That's one specific piece of data.
Right, for sure.
Yeah.
So it's very slow to adopt. The law is very slow to move, to change, and so being knowledgeable about the state that you're in, the state laws, but then also any sort of overarching federal law is also important. And so in the realm of what I do, knowing eavesdropping law is important, and that's a state law. Knowing biometric data privacy, that's a state law as well. And so those are sort of the operative ones. It would be great if we had something like what California has as far as like data removal, and GDPR obviously is sort of the gold standard right now. That would be great if we had something along those lines in this country, but we're not quite there yet.
Yep. Yeah. So I'm curious, we've got all of this stuff that you've laid out, all of which great advice, especially for people, unfortunately, going through a separation process. When you kind of wrap up working with a client on a case like this, do you find that their own cybersecurity practices generally have improved as a result of this? And do you also give them some kind of parting advice like, hey, going forward, these are some good practices in your just personal data hygiene, personal cybersecurity approaches? And if so, what are some of those things that you share with them?
The hope is that they learn something along the way. It's a mixed bag. Some clients are, candidly, they're inconvenienced, and there's that inverse relationship between security and convenience. Two-factor authentication is just one more friction point, right?
Yep.
But it has immense gains in terms of security. So anytime that I tell a client, stop sending me email attachments and use this link, it's just one more step for them. It's just maybe they have to type in their email address, and they have to wait for a code that sends to their email, and they have to type that in. And Some of them are annoyed. It's just, I
Yeah.
just want to send you an email attachment. I just want to call you on the phone. I don't want to use Signal, or I just want to send you a text message. But then there are the other side of that equation is the people that either didn't know and now they feel like their eyes are opened and they're
Yeah.
thankful, or there's some that did know and they're just appreciative that I also know and that I'm caring about, preserving their security and preserving their privacy. And so along the way, a divorce case can take 2-3 years. And so they're picking up tips along the way about, their surveillance cameras and their social media accounts, and using secure email providers and using Signal and using secure file upload services. And while I'm pushing them in each of these directions, because I just have an interest in the topic in general, I'll explain to them along the way. I'll tell them, while you're on a Proton Mail, why don't you use Proton Drive and stop using Google Drive? And so the hope is that, post-divorce, I'm out of their life and now they're onto a more secure platform. They're using a more secure cloud storage, a more secure email, a more secure messenger. Maybe I've even got them to use a better privacy respecting browser. So, the hope is that they take some of those things with them. And as you know, cybersecurity isn't a light switch. It's a continuum, and it's an evolving thing. And so if they're doing little things, they're making themselves a little bit more secure than the person next to them. And that's really all I can ask of clients.
And hopefully, above all, they're using two-factor on anything sensitive, right, along the way. I think that one, I've had a number of guests on the show who work in the authentication and identity fields, and that always comes through as kind of, if you could tell individuals to do one thing, that seems to be the pretty consistent, unanimous number one. I'm curious about something else. How did you get started on this? What was the journey that kind of pulled you down this path? Because it sounds like you started with a law degree practicing family law, but now it sounds like you've gone pretty deep on understanding this intersection in the digital privacy space and all of the implications. So what was the journey?
Yeah, so, I've always been sort of privacy focused. I've been on like Signal and Proton Mail since, 2016, around then. And those things have always appealed to me on a personal level. And, I've recognized the need in clients that come in that vulnerable state and saying, help me navigate this problem. And most lawyers in my position, you mentioned this in your gracious introduction, that good luck finding a lawyer that also wears a cybersecurity hat. It just doesn't happen. And so most of the time, like a lawyer will tell you, I don't know, go hire a private investigator and they'll do a sweep of your house for, AirTags or things like that. And maybe that works and maybe it doesn't. But, when COVID hit and people went down their various different rabbit holes of, either watching Tiger King or learning how to bake bread or whatever people did, I went down a different rabbit hole that I haven't found the bottom of quite yet, and it was this cybersecurity stuff. And so I did, the Security Plus training. I watched hours and hours and hours of YouTubes and podcasts and read as much as I could get my hands on as far as like actual literature goes, and just tried to make myself as knowledgeable about it as possible so that I could be a resource to clients, so that I could learn more for myself, for my family, for the kids. Because that's part of the job above advising clients is keeping the kids safe, keeping the family safe, and it all just sort of played into each other.
Yeah, awesome. By the way, I'll let you in on a secret that you probably already picked up on by now, but there is no end to the rabbit hole. Unfortunately, the deeper you go, you can find a threat for pretty much any control, and you can find a circumvention for pretty much any control. And there's definitely some truth. And when I make this statement, and you'll hear it not only from me, but I wasn't the first person to say it by any means. Anybody who has the time, determination, and resources and really, really wants to hack you will be able to. The things that you can do are check the boxes on all the basics, practice good hygiene, practice good, good basics, turn on two-factor, especially for your personal email. It sounds like out of this conversation. So I'm curious. So you went down that rabbit hole. You've learned a ton. It sounds like you do great work advising your clients from everything that I've heard on the conversation today. What do you say to other law firms and other lawyers? do you tell them, hey, advise your clients the same? Or do you say like, hey, you should think about just doing better cybersecurity for yourself as a law firm? Or what are some of the things that you've kind of shared with your colleagues?
I mentioned earlier that the law is slow to change, so I may never succeed in convincing anybody else to do this, but if I could get law firms to stop using Microsoft Teams and use Signal, if I could get law firms to stop using Office and start using Proton Mail, if I could get offices to stop using OneDrive and use Proton Drive, or anything that's a little bit more security focused, privacy focused, I would consider myself a success in this field, because there's a very common misconception that my emails in their inbox, they're encrypted, and when I send them, they're encrypted in transit, so we're good to go. And what law firms aren't understanding is that they're encrypted in your mailbox and they're encrypted in transit, but you have the key and Microsoft has the key, or you have the key and Gmail has the key. So if they want to use that key, if they want to access your emails, they can. And as lawyers, we have a high obligation to our clients. We have an attorney-client privilege that we need to maintain. And so I think it's incumbent upon law firms to take whatever measures are appropriate or whatever measures are necessary to preserve that privilege. And that's going to include using the most secure options available. And those just are not Gmail, Outlook, Office, Teams.
Yahoo.
Those are convenient. But they're not the most secure. And so, that would be the encouragement that I would give to other law firms, is to consider some of these more privacy respecting options. And, the transition doesn't have to be hard. It doesn't have to be a lot of friction for the employees. Having Proton Mail as your back end could be seamless. Your employees may not even notice that that's what's running in the background. So that would be my suggestion.
Awesome. And what are your predictions? How do you think this field changes over the medium term? Because when I kind of look at it right now, all I see is more of the same. I don't see a mass movement to change away from the way things are generally working in most people's lives. And if anything, I see more information going digital all the time. And in fact, in many states nowadays, we're seeing driver's license going digital, and that's in your Apple Wallet or your Google Wallet now. So it seems to be kind of a one-directional, more and more digital. What do you think about? What do you see coming down the line?
I don't have a very optimistic outlook. If anything, it's going to get worse. The prevalence or the frequency of phishing and business email compromise, that's going up, and that's going to continue to go up. To your point earlier about are we targetable? Maybe. But that sometimes hackers are just looking for a soft target. They're not necessarily looking for the wealthiest target. So people don't think that they're likely to be targeted, and they're the next target. And the data broker stuff is just getting worse and worse, and so people's personal information's out there, which is just making phishing all that much easier. And I think that's going to continue to happen, frankly, until a person on Congress has their information released through a data broker. Then something might change. But until that happens, that problem is going to continue to get worse. That's going to keep feeding into phishing. That's going to keep feeding into business email compromise. And things are going to get worse. And, we're going to do things, innovation along the way to try to keep pace. I think passkeys is helpful for people that have terrible password hygiene. But the implementation or the rollout of that seems to be sort of stumbling along slowly. So, ideally, those sort of innovations are going to keep pace with the increased prevalence of threats, but it doesn't seem like that.
Yeah, it was interesting. Passkeys had a lot of momentum there for a minute, and, kind of 5 or 6 major services adopted them. And, I've certainly switched over my Gmail to using passkeys, and I've got 2-factor turned on. And by the way, I also have a hardware authentication device for my Gmail as a backup option and required on new devices, first-time authentication. But to your point, it seems to have kind of fizzled after that initial rollout across. Granted, those were some big global services that were some of the first adopters and pushed them out, but it doesn't seem to have been the solution, or not yet at least. So, look, I think I agree with you. And while I can confidently say that I speak for you, that neither of us would encourage any data brokers to go after members of Congress or expose their data, I do think you're right that it's going to take something pretty big and to happen to somebody in a position of power to really initiate some change on that front. So, Jonathan, just in the couple of minutes that we've got left here, what are some of the things that you're working on? If people want to find your work, how can they do that? We'll post the links in the show note of anything that you want to share with the audience.
The next thing on the horizon for me is another certification that I would like to obtain. That would be the Certified Ethical Hacker certification.
Nice.
That's on the horizon. If I can make some time for that, that's what I would like to do. Making time, of course, is difficult, but that's the hope. To contact me, I've got two websites that I could point your listeners to. Would be steelefamlaw.com. That's got all my social media handles aggregated into one convenient place. Or steelefortress.com has more information about cybersecurity, privacy. I've got a blog there. It's got all my contact information as well. Either of those, you'll end up in my inbox or my Signal inbox, and I'm happy to answer any questions for anybody that has them for me.
Awesome. And we'll get both of those links posted in the show notes, as I mentioned. Jonathan, thank you so much for taking the time. This has been a really interesting conversation. And like I said to everybody in our audience, I know it's a little bit of a off the beaten path for us to go into personal cybersecurity, but it is a very, very important topic. All of us are individuals, people in the real world, family, loved ones, connections. Some of the advice shared on the episode today, I think, applies to pretty much everybody, whether you're in a family law situation or not. So Jonathan Steele, thank you so much for taking the time to share your wealth of experience and knowledge on this subject and for joining us on Modern Cyber.
Thanks for having me.
All right. To everybody in the audience, remember, we will talk to you next time on the next episode. And if you know somebody else that you'd like to nominate to come on the show, please let us know. Reach out anytime. For me, Jeremy, and the whole Firetail team, thanks for joining us on this episode of Modern Cyber. Bye-bye.